All right, let's unlock some serious knowledge today. We're embarking on a comprehensive, yet hopefully truly engaging deep dive into the intricate, often surprising, and incredibly dynamic world of California real estate.
Mm-hmm.
Think of this as your personal, essential audio study guide, designed to cut through the jargon, illuminate the complexities, and get straight to the heart of what you need to know.
Exactly.
We're going to uncover the fundamental concepts, explore the vital legal frameworks, and dive into the practical applications that are absolutely essential for anyone stepping into this industry or even just satisfying a deep curiosity about, well, what are the biggest investments of our lives?
Yeah.
Get ready for some genuine aha moments.
That's precisely our aim. Our mission in this deep dive is to distill the most vital information from extensive material, focusing on the core principles and, critically, their real-world implications.
Right.
We want to help you build a solid foundation of understanding quickly and thoroughly, equipping you to navigate this fascinating field with confidence and clarity.
And to be really clear about our scope, this deep dive will systematically unpack the key areas of California real estate. We're starting with the very foundational definitions and then moving all the way through the nuances of property transactions and, just as crucially, professional ethics.
It's a big landscape.
It's a lot to cover, but we're going to make it accessible and, dare I say, entertaining. So let's get started. Let's kick things off with a fundamental question. What exactly is real estate? Because for most of us, it just conjures images of houses, but it's so much more, isn't it?
It absolutely is. And what's often fascinating here is how these terms build on each other, moving from a simple physical concept to a much more complex legal one.
Okay.
When we talk about land, for example, we're not just referring to the soil beneath your feet. Land includes the surface, yes, but it also extends downwards to the minerals and resources that lie beneath. Think oil, gas, precious metals.
Wow.
And theoretically, it stretches upwards into the air above, almost to infinity. It's like imagining a column of earth and sky. Then we add a layer with real estate. This concept builds directly on land by incorporating human-made improvements.
Improvements.
Like buildings. Exactly. An improvement is any non-natural structure that's been built on or permanently affixed to the land. So while a house is the most obvious example, it could also be a fence, a driveway, a swimming pool, or even extensive permanently installed landscaping.
Right.
The critical element is that it's something created by humans and fixed in place on the land.
Got it. Fixed.
Finally, we arrive at real property. This takes real estate and adds something truly crucial: the bundle of rights associated with ownership.
Ah, the bundle of rights?
Yes. So it's no longer just the physical thing itself. It's the comprehensive set of legal rights and privileges that come with possessing that physical thing. This distinction is absolutely vital because those rights dictate what an owner can actually do with their property and how deeply their ownership extends.
This immediately brings up a critical question. What exactly is in this bundle of rights that truly defines ownership? Because it sounds like it's far more than just, living on the property.
You're right, it's a powerful concept. The bundle of rights is a metaphorical collection of all the legal privileges and interests that a person has in a piece of real property. We typically identify 6 core rights, and they're important because they define the scope of true ownership.
Okay, what are they?
First, there's the right of possession. This means you have the exclusive right to occupy the property, to call it yours. Second, the right to control the property, allowing you to use it in any lawful way you choose within the bounds of, zoning laws and other regulations, of course.
Makes sense.
Third is the right of quiet enjoyment, which can be easily misunderstood. For a property owner or even a lessee, this is the right to possess and use the property peacefully without interference from a previous owner, a landlord, or anyone else asserting a claim to the title. It's about undisturbed use.
Okay, peace and quiet, legally speaking.
Sort of, yes. Fourth is the right of exclusion, empowering you to prevent others from using or entering your property. Think of it as the legal backing behind putting up a no trespassing sign.
Right, keep out.
Fifth, the right to transfer, meaning you can sell, lease, give away, or even bequeath the property in a will. And sixth, the right to encumber, which means you can place a lien or mortgage on the property using it as collateral for a loan. When you put all 6 of these rights together, that's what constitutes full, comprehensive ownership of real property. It's a very complete set of legal powers.
Okay, this next distinction often trips people up. The difference between real property and personal property. Why does it matter so much if my detached shed or that fancy new ceiling fan is labeled real or personal? What are the real-world headaches if we get this wrong?
That's a perfect question because it dictates how items are conveyed during a sale, how they're taxed, and even how they might be inherited. It's actually pretty fundamental. Real property, as we just established, is permanently attached to the land or to improvements on the land. When real property is sold, it's transferred via a deed or a will, and it fundamentally stays with the property. Your house itself, a permanently installed garage, or a built-in fence are all classic examples of real property.
Right, the fixed stuff.
Exactly. Personal property, on the other hand, is anything that's movable and impermanent. It's also often referred to as chattel.
Chattel, okay.
Personal property is conveyed by a bill of sale, and it generally goes with the seller when the property changes hands. Your furniture, your car, or even a freestanding refrigerator are all considered personal property.
Gotcha. So if it's not nailed down.
Pretty much, although it's a bit more nuanced than that sometimes. Now, to add a fascinating layer, consider plants. Fructus naturalis are things like mature trees, perennial plants, or wild uncultivated plants. Because they are long-term and generally permanent, they are considered real property.
Like a big old oak tree.
Exactly, that grand oak tree in the front yard. But then there are Fructus industrialis, also known as emblements, which are annually cultivated crops like corn, wheat, or cotton.
Ah, crops.
Yes. Even before they're harvested, these are generally considered personal property because they require human labor annually and are intended to be harvested. So if you're buying a farm, that year's corn crop, even though it's rooted in the soil, might actually be personal property and not automatically included in the sale of the land itself.
Huh. That is surprising. You wouldn't think corn still in the ground is personal property.
It's a common misconception. It highlights how these legal definitions matter in practice.
So that leads us directly to fixtures, objects that start as personal property but become real property. How does that transformation happen, and what's the trick to figuring out if something is a fixture when you're looking at a home?
A fixture is the quintessential example of this transition. It's an object that began its life as personal property, perhaps something you bought at a hardware store, but then became so firmly attached to the land or a building that it's now considered real property.
Okay.
The process of making something a fixture is called affixation or annexation. A very common example is a ceiling fan. You buy it in a box as personal property.
Right.
Once you install it, wire it into the electrical system, and permanently bolt it to the ceiling, it has transformed into a fixture and thus real property. This becomes crucial in a sale. If it's a fixture, it typically conveys with the house unless explicitly excluded.
Okay, so how do you tell? Is there a test?
There is. To determine if something is a fixture, especially if there's no written agreement, we use a helpful mnemonic device called Mariah. This stands for 5 key tests.
Mariah.
Yeah. The method of attachment. How is the item attached? Is it permanently bolted, wired, cemented, or just resting on the floor? The more permanent the attachment, the more likely it's a fixture.
Makes sense.
Adaptability. Is the item custom-made for the property, or does it adapt to the property's specific use? For example, custom-built bookshelves fitted into a specific nook or specialized machinery in a factory suggest it's a fixture.
Like it belongs there specifically.
Precisely.
Right.
Relationship of the parties. This considers if the person who attached the item is the buyer, seller, or tenant. This can influence the outcome, as tenants often have different rights to remove items.
Okay.
Intention. This is often the most important and sometimes trickiest factor. What was the original intention of the person who installed the item? Was it truly meant to be permanent or temporary? This can be inferred from the other factors.
Intention sounds subjective.
It can be, which is why the last one is so important. Agreement. This is the simplest and most definitive. If the buyer and seller agree in writing whether an item is staying or going, perhaps explicitly listing the ceiling fan in the contract, that written agreement overrides everything else.
So write it down.
Absolutely. Clear communication is vital. Now, it's important to contrast this with trade fixtures.
Trade fixtures. Different.
Yes, these are a special category. Items owned by a tenant and specifically necessary for their business, such as a display case in a retail store or specialized machinery in a factory. While they are affixed, the general rule is that tenants can remove them when they leave, provided they repair any damage caused by the removal.
So business stuff is different.
Generally, yes, this is an exception to the general fixture rule. And then severance is the opposite of affixation. It's the act of converting real property back into personal property, like digging up that perennial plant we mentioned earlier to take it with you when you move.
So we've talked about properties and the things on them. Now let's dig a bit deeper into the land itself. What are its unique characteristics, and how do they really impact its value and how we interact with it?
The land itself possesses several truly unique physical characteristics that set it apart from virtually any other asset. First, it's indestructible. You can't truly destroy land, even if you dramatically change its topography.
Right, you can move dirt around, but the land is still there.
Exactly. Second, it's immobile, also known as fixity real estate, exists in a fixed, immovable location. This immobility is precisely why location is the golden rule in real estate. You can't pick up a great house from a bad neighborhood and move it.
Can't argue with that one.
And third, it's non-homogeneous, meaning every single parcel of land is unique. No two parcels are exactly the same, even if they're side by side, because their specific location, orientation, and subtle features will always differ.
Every spot is unique. Got it.
Beyond these physical traits, natural geological processes can profoundly affect land. Accession refers to your right to whatever your property produces naturally or what's naturally added to it.
Like fruit from a tree on your land.
Or new soil deposited, yes.
Okay.
Accretion is the gradual increase in land area due to soil deposits by natural forces, like a river slowly building up new land along its banks over decades. The opposite is erosion, the gradual loss of land over time due to natural forces like wind or water.
Okay, accretion adds, erosion takes away.
Correct. Reliction is a gradual increase in land area when water gradually withdraws, exposing new land, such as a lake shrinking over time. And then there's avulsion, which is the sudden and often dramatic loss of land, perhaps due to a severe flood that washes away a chunk of riverfront property or a river suddenly changing its course.
Wow, avulsion sounds serious.
It can be. Economically, land also has distinct characteristics that dictate its market behavior. Scarcity is a huge one because land is finite. Less available land generally means it's worth more, informing supply and demand dynamics.
Basic economics.
Then there's situs, which refers to the economic significance and desirability of a property's location. This isn't just about the physical spot, but how economically advantageous or appealing that location is for businesses, quality of life, or development.
So more than just location, it's like the economic power of the location.
Yep. Exactly. And finally, illiquidity, meaning real estate, can be quite difficult to convert into cash quickly without potentially incurring a significant loss of value, unlike, say, a stock that can be sold with a few clicks. It's a long-term investment by nature.
And then we have appurtenances.
Yeah.
These intriguing rights that run with the land and can even be sold separately. What exactly are those, and how do they function in the real world?
Appurtenances are rights that are inherent to the land and automatically transfer with it when it's sold. They are said to run with the land.
Okay, like what?
This can include several important categories. For instance, air rights govern the space above the property. In dense urban areas, these air rights can be incredibly valuable and sometimes sold separately for the construction of high-rise buildings.
Right, building upwards.
Then you have surface rights, which govern what happens on the immediate surface of the property, including its natural elements and any improvements. Beneath that are subsurface rights, often known as mineral rights, dealing with resources like oil, gas, or minerals found below the surface.
Mineral rights. That can be complicated.
It can. What's often critical to understand here is that holders of subsurface rights can sometimes have priority over surface right holders, provided their activities don't unduly disturb the surface. You also have supporting rights, which are crucial for maintaining the integrity of your land. Lateral support comes from adjacent properties, preventing your land from collapsing into a neighbor's excavation, for instance.
So your neighbor can't dig a giant hole right next to your property line and make your house fall in.
Generally, no, they have a duty to provide lateral support. Subjacent support is from below, important in areas with mining operations. And lastly, water rights are a complex but vital area, and they vary significantly by state or even municipality.
Water rights seem like a big deal, especially in California.
Huge deal. These can operate under systems like prior appropriation, common in drier western states, where the first to use the water gets the right. Or under common law systems, you might have riparian rights for properties bordering flowing bodies of water like rivers, or littoral rights for properties bordering still bodies of water like lakes or oceans. All these different types of appurtenances collectively define the comprehensive aspects of what one truly owns and controls when they acquire land.
Let's shift gears now to the operational side of real estate, specifically the regulatory landscape in California. Who exactly oversees real estate professionals, And what are the specific rules and powers that agency has?
In California, the primary oversight body is the California Department of Real Estate, or DRE. Its mission is distinctly dualfold. First, and paramount, is to regulate and monitor the real estate industry to safeguard the public's interest in all real estate transactions, whether residential or commercial.
Public protection, number one.
Absolutely. And second, it strives to efficiently provide services related to licensing, subdivision approvals, and various consumer needs. The DRE is quite powerful in achieving these goals. It approves education providers, administers licenses, investigates complaints, and takes formal disciplinary actions.
So they handle the whole life cycle, from education to discipline.
Pretty much. It also manages the consumer recovery account, enforces subdivision laws, handles funds for education and research, and monitors mortgage broker activity. It's a truly comprehensive regulatory body designed to keep the playing field fair and protect consumers from, unscrupulous practices.
And who's in charge there?
Heading the DRE is the Real Estate Commissioner, a position appointed by the Governor of California. The commissioner's job is not just ceremonial. They actively create and enforce policies that are designed to protect the public. They also hold formal hearings for licensees and license applicants.
Hearings, like trials.
Sort of, administrative hearings. The outcomes of these hearings can be quite significant, ranging from imposing strict license restrictions, limiting what a licensee can do, to temporary suspension or even permanent revocation of a license, or outright denial of an application for those trying to enter the field. It's a position with considerable authority.
So if I'm looking to get into real estate, what actions specifically require me to have a license in California? And are there any surprising exceptions where you don't need one?
That's a great question, and it's essential to get right. To perform any of these activities for compensation, meaning you're getting paid for it, a California real estate license is required. Selling or offering to sell real estate, purchasing or offering to purchase it, seeking prospective sellers, buyers, or tenants for a listed property, listing real estate, negotiating an exchange of real estate.
Basically anything involving helping someone else buy, sell, or lease property for money.
Exactly. Also, leasing or renting property, collecting rent on behalf of another, helping someone complete an application to purchase or lease state or federal land, seeking, negotiating, or collecting payments on loans secured by liens on real property, or selling, buying, or exchanging real estate sales contracts secured by liens. It's quite an extensive list, clearly covering most aspects of brokering a transaction for others.
Okay. What are the exceptions? Where don't you need a license?
Right. There are indeed notable exceptions where a license is not required, and some might surprise you. For instance, if you're selling, purchasing, or leasing real estate on your own behalf, you typically don't need a license.
Okay, for sale by owner is fine.
Generally, yes. The exception to this is if you're buying, selling, or exchanging 8 or more sales contracts within a year, which then brings you under the DRE's jurisdiction.
Oh.
Also, acting under a power of attorney from the property owner, performing duties as a licensed attorney, or acting in a court-appointed role like a receiver or trustee are all exempt.
Right, legal roles.
Resident managers or employees of certain residential or temporary housing facilities are exempt, but their duties are quite limited to things like supervising the building, showing units, accepting pre-printed applications, providing lease information, accepting signed agreements, or collecting security deposits and rents. They can't negotiate or anything like that.
Got it. Very limited scope for them.
Correct. Employees of lending institutions, auctioneers performing limited real estate functions, approved federal loan servicers, cemetery landowners and their employees, cooperative agricultural associations, and licensed personal property brokers or finance lenders while performing their licensed duties are also exempt. Finally, unlicensed assistants can perform limited administrative functions but cannot engage in licensed activities.
So once you've successfully cleared that hurdle and you're licensed, what are the ongoing requirements you need to meet to keep that license active? And what are the common pitfalls that could land you in hot water with the DRE?
Once you're licensed, both brokers and salespersons in California face continuing education requirements. For your first renewal and for every renewal thereafter, you need to complete 45 hours of DRE-approved continuing education coursework.
45 hours every renewal period.
Yes. There's a notable exemption, however, for individuals who are 70 years old or older and have practiced real estate with their licenses in good standing for 30 continuous years. They can be exempt from these CE requirements, which is a nice perk for seasoned professionals.
30 years and 70 years old.
Yeah.
Okay. What gets people in trouble?
As for pitfalls, there's a clear list of common license law violations. These include any form of dishonesty, such as outright fraud, making material misrepresentations, or false promises, failing to make proper disclosures, acting in an untrustworthy or incompetent manner, or failing to get the owner's explicit written consent when selling their property are also serious.
Common sense stuff, mostly, but important.
Right, but easy to slip up. Accepting payment from someone other than your employing broker or failing to include a definite termination date in an exclusive contract are also violations. Practicing law without a license, a common trap for agents who try to give legal advice.
Don't play lawyer.
Definitely not. Improperly handling client funds, violating fair housing laws, keeping documents and records improperly, acting without a license, or having certain prior criminal convictions, even if seemingly unrelated, can all lead to disciplinary action.
And what kind of discipline are we talking about?
The DRE has a range of disciplinary actions they can impose after a hearing. This can include refusing to allow an applicant to get a license in the first place, restricting an existing license, limiting the types of real estate acts a licensee can perform, suspending an individual's license, a temporary loss of privileges, or even permanently revoking it, which is the most severe penalty.
Revocation. That's serious.
Very. They can also impose fines of up to $2,500 per investigation, depending on the severity and nature of the violation.
Shifting gears slightly, how are brokerages actually structured in California? And crucially, who's responsible for what, especially when it comes to the actions of everyone else working there? The chain of command and liability seems important.
It's incredibly important. In a California brokerage, you'll typically find several key roles, and understanding them is crucial for liability. There's the responsible broker, who holds the primary broker license and has ultimate authority and responsibility for the firm.
The boss.
Essentially, yes. Then you have broker associates, who are licensed brokers themselves, but choose to work under another responsible broker for various reasons. Salespersons must always operate under a responsible broker. They cannot operate independently. And finally, unlicensed employees handle administrative tasks.
Okay, so broker associate, salesperson, unlicensed staff. Who's on the hook?
Here's the critical insight. The responsible broker is held liable for the activities of all associated firm members. This includes not only their salespersons and broker associates, but also independent contractors working for the firm and even administrative staff or unlicensed personal assistants.
Wow, everyone, even the admin.
Yes. The buck truly stops with the responsible broker. This is why their oversight is so vital. They need robust policies and training in place.
Makes sense. What about those unlicensed assistants? What can they do?
Speaking of unlicensed assistants, their functions are very specific and limited to clerical duties, bookkeeping, accounting, and other administrative support tasks. They absolutely cannot do anything that requires a real estate license, like showing properties, discussing terms, or negotiating offers.
Strictly admin, paperwork.
Correct. Independent contractors, in contrast, work according to their own methods and are responsible only for the results of their work, but their actions still fall under the responsible broker's ultimate liability, reinforcing the importance of clear agreements and supervision.
Let's talk about money. What are the critical record-keeping and financial rules that real estate professionals must follow to protect both their clients and themselves from a financial standpoint?
California law is exceptionally clear and strict on record retention. All transaction documents and escrow records must be maintained for a minimum of 3 years.
3 years. That's the magic number.
It is. This isn't just a suggestion, it's a legal mandate. This includes an extensive list. Listing agreements, inspection reports, all agency and property disclosures, accepted and rejected offers, all material correspondence, emails, letters, property management agreements, and lease agreements. It's absolutely vital to keep every piece of paper or its precise digital equivalent to demonstrate compliance.
So keep everything for 3 years. What about digital records?
Electronic record keeping is certainly permitted in our modern age, but it comes with strict stipulations. The responsible broker must implement a system that ensures these records are secure, authentic, and accurate. If access is ever required by the DRE or for legal purposes, they must be readily readable and available upon request.
So not just saving files randomly, but a real system.
Exactly. This isn't just about saving physical space. It's fundamentally about maintaining data integrity and accessibility for regulatory compliance. As for financial rules, trust accounts are paramount.
Trust accounts? For client money, right?
Precisely. Their fundamental purpose is to keep client funds like earnest money deposits entirely separate from the brokerage's operational accounts or the broker's personal funds. Earnest money, for instance, must be deposited into a trust account within 3 business days of receipt, unless a buyer's check is specifically held until the offer's acceptance. In that case, it must be deposited within 3 business days after
Three
acceptance.
business days, okay.
Trust account records, just like other transaction documents, must also be retained for 3 years after the closing date of the transaction. This rigorous separation of funds is a cornerstone of ethical practice.
This raises an important question, and it's a common one that new agents often get confused by. What's the difference between commingling and conversion, and why are they both considered illegal even if no money is stolen?
This is a really, really important distinction, and it's one that real estate professionals must understand to avoid serious violations. Commingling is simply the illegal act of mixing personal funds with a client's funds.
Just mixing them together.
Yes. For example, if a broker puts their own personal money, even just a few dollars, into the client trust account or vice versa, that's commingling. Even if the client's money is never spent, the mere act of mixing it with personal or operational funds is strictly prohibited because it compromises the clear, transparent separation of monies.
So even if you don't touch the client's money, just putting your own in there is bad.
Correct. It creates a gray area where there shouldn't be one, and it's seen as a gateway to more serious issues. Conversion, on the other hand, is an even more severe offense, and it usually follows commingling. This occurs when funds which have likely already been commingled are actually spent on something other than their intended purpose.
Ah, spending the money. That's conversion.
Exactly. It's the illegal appropriation of client funds. So, to use our example, if a broker mixes a client's earnest money with their personal checking account, that's commingling, and then uses some of that money to pay their office rent, that's conversion, both acts are illegal.
Commingling first, then conversion.
Often, yes. Commingling is the act of mixing. Conversion is the act of spending those mixed funds inappropriately. The penalties for conversion are much more severe because it involves actual misappropriation of client money. There are only 2 very narrow exceptions in California where a broker's personal funds are allowed in a trust account. Up to $200 to cover legitimate bank service fees, as trust funds themselves cannot be used for these.
Okay, for bank fees.
And commissions or fees earned by the broker that may remain in the trust account for up to 25 days from their deposit to facilitate clear accounting. These exceptions are highly specific to prevent inadvertent commingling for administrative necessities.
Got it. Very specific rules there. When we talk about ethics in real estate, how is that different from strict laws or even just our personal morals? And why does this distinction matter so much for someone working in the field?
That's a fundamental question, and it's crucial for understanding professional conduct. Let's break it down. Laws are external rules enforced by a governmental authority, like speed limits or specific disclosure requirements in real estate. They are legally binding, and breaking them carries penalties, fines, jail time, license revocation.
Laws, government rules, penalties.
Right. Morals, conversely, are personal values. They're an internal compass derived from an individual's belief system. They vary greatly from person to person, shaped by upbringing, culture, and personal experiences.
Morals, personal, internal.
Correct. Ethics, however, are standards of conduct agreed upon and recognized by a particular group or culture, often a professional association. The main differentiating factor is that ethics are determined by an external group and are standardized for that group, while morals are internally held and individual.
Ethics, group standards, external.
So, while your personal morals might guide you, a professional code of ethics sets the bar for everyone in that specific profession. It's also important to clarify a common point of confusion. Simply getting a real estate license in California does not automatically make someone a realtor.
Oh, good point. License holder versus realtor.
Exactly. A person with a license is a license holder. Only license holders who are voluntary members of the National Association of Realtors, or NAR, must adhere to NAR's Code of Ethics. While not all license holders are realtors, it's worth noting that almost every state, including California, has developed laws that parallel many of the principles outlined in the Code of Ethics, reflecting its strong influence on the industry.
So the Code of Ethics is influential even if you're not a realtor.
Very much so. The NARA Code of Ethics, first adopted way back in 1913, was established to set a higher standard for conducting business properly and to build public trust in the profession. It demands that realtors treat all parties, not just their own clients, but everyone involved in a transaction fairly and honestly.
Treat everyone fairly, not just your client.
That's a crucial distinction and often goes beyond what the law explicitly requires. While it sets a higher standard than the law, if there's ever a conflict between the code of ethics and the law always takes precedence.
Law trumps ethics if they conflict. Got it. What's truly foundational here, and what really anchors the entire code of ethics?
The overarching mission of the Code of Ethics is powerfully articulated right in its preamble, echoing a timeless universal principle. It states, "Realtors can take no safer guide than that which has been handed down through the centuries, embodied in the Golden Rule, whatsoever ye would that others should do to you, do ye even so to them."
The Golden Rule. Simple but powerful.
It's the bedrock upon which the entire code is built, guiding the 17 articles that follow. Those articles are systematically organized into 3 sections, defining distinct duties. The first 9 articles cover duties to clients and customers, emphasizing loyalty, confidentiality, and honesty.
Duties to clients.
Articles 10 through 14 address duties to the public, focusing on non-discrimination and upholding public trust. An example of an illegal and unethical act under duties to the public is blockbusting, which is the practice of causing owners to sell their homes by creating fear about protected classes moving into an area.
Blockbusting. Definitely unethical.
And illegal. Finally, Articles 15, 16, and 17 outline duties to realtors, promoting professional courtesy and cooperation within the industry. The code really aims to guide professionals through ethically tricky situations, ensuring fairness and honesty in every interaction, striving for a level of conduct above mere legal compliance.
If disagreements or even ethical breaches arise, how are ethical complaints and disputes typically handled within the realtor community? It sounds like there's a specific process to keep things fair.
You're right. The realtor community has established clear, tiered processes for dispute resolution designed to maintain the integrity of the profession and resolve conflicts efficiently. If a disagreement first arises, often the initial step is the mediation process.
Mediation first. Less formal.
Generally, yes. In this scenario, the local board of realtors assigns a mediation officer who helps both parties calmly explain their points of view and work towards finding a mutually acceptable resolution. If they reach an agreement, it's put in writing and becomes binding. If no agreement can be reached through mediation, the case can then potentially move to arbitration.
Okay, if mediation fails, then arbitration.
Correct. The arbitration process is more formal than mediation. A realtor files a request for arbitration, and a grievance committee first determines if the issue is arbitrable, meaning is it something that can be resolved through this process, usually commission disputes.
So not every issue goes to arbitration.
Right. If it is arbitrable, a formal hearing panel conducts a full hearing, complete with witnesses, sworn testimony, and evidence presented by both sides. A determination is then made, and monetary awards can be issued to the winning party, particularly in commission disputes.
Okay, like a mini court for money issues. What about ethics violations?
For alleged ethical breaches, there's a distinct ethics complaint process. A written complaint is filed, and the grievance committee assesses its merit. If they determine it has merit, a formal hearing is held where the Professional Standards Committee acts essentially as judges, hearing from witnesses and reviewing all evidence.
Professional Standards Committee. Sounds official.
It is. They decide if an ethical breach, based on the Code of Ethics, occurred, and if so, what disciplinary action should be taken against the realtor, ranging from required education to fines, or even suspension or expulsion from the association. It's a structured system designed to ensure accountability and uphold professional standards.
And anything else besides these formal processes?
Additionally, beyond these formal processes, NAR actively promotes what they call pathways to professionalism. These are voluntary courtesies and best practices designed to encourage respect for the public, respect for property, and respect among peers. While not mandatory rules, they serve as a guide for exemplary professional conduct, fostering a culture of higher standards and mutual respect within the industry.
Let's move into one of the biggest areas of potential liability for sellers and their agents: property condition. What must be disclosed in California, and what are the critical differences in defect types that everyone involved should understand?
This is truly a cornerstone of protecting all parties in a real estate transaction. In California, sellers of residential real property are legally required to disclose known material facts about their property to the buyer through a very specific written form called the Real Estate Transfer Disclosure Statement, or TDS.
The TDS, that's the big one, right?
It is. This comprehensive form covers everything from fixtures and the property's structural integrity to environmental and natural hazards, and even public controls like zoning. It's designed to ensure maximum transparency. A crucial buyer protection built into this is that if the TDS is delivered after an offer has been made and accepted, the buyer then has a 3-day right to cancel their purchase after receiving the disclosure form.
3 days to back out if the TDS comes late. That's important.
Very important. It gives them time to review and react.
So when we talk about defects, what exactly is the difference between a latent and a patent defect? And why does that distinction matter legally?
That's a key legal distinction. A latent defect is a structural flaw or issue that is not readily detectable by an ordinary reasonable inspection. Think of a hidden plumbing leak behind a wall, a foundational crack concealed by landscaping, or a persistent mold problem behind a fresh coat of paint.
Hidden problems, the scary ones.
They can be. Both the seller and their agent have a legal duty to disclose these known latent defects to potential buyers. The surprise here is that many problems aren't obvious, yet legally, you must reveal them if you know. A patent defect, conversely, is a flaw that is easily discoverable upon a reasonable inspection.
Obvious stuff, like a broken window.
Exactly. A broken window, a clearly peeling paint job, or a visibly cracked driveway. While there might be less legal liability for the seller regarding patent defects because they're visible, it's always best practice for sellers to disclose all known defects, regardless of whether they're latent or patent, to avoid any disputes down the line.
Just disclose everything you know. Safer that way.
Transparency is always the best policy. Licensees themselves also carry significant responsibility beyond simply passing on seller disclosures. They have an affirmative obligation to disclose any material facts they should have known, given their expertise and diligence during their own property inspection, or any material facts that were explicitly made known to them by the seller or others.
So agents have to look for problems too, not just pass along the seller's info.
Correct. A licensee can be held liable for accidental misrepresentation, knowingly making a false representation of a material fact, or even for concealing or aiding the seller in concealing a material fact. The standard is quite high, expecting agents to be both knowledgeable and diligent in their own visual inspections.
Beyond these basic disclosures, how do tools like home inspections, home warranties, and even hazard insurance fit into protecting buyers and sellers in what is often the biggest transaction of their lives?
These elements form crucial layers of protection for all parties. The home inspection is an absolute must-have for the buyer. Its primary purpose is to locate any physical faults or significant issues that might affect the safety, structural integrity, or value of a home.
The buyer gets their own inspector.
Right. This often reveals important defects that aren't obvious to the untrained eye. Buyers typically pay for these inspections, although it's always negotiable in the purchase agreement. Now, a critical California-specific point that often surprises people, the agent's due diligence property inspection.
Agent's inspection, separate from the buyer's.
Yes. California law requires both the seller's agent and the buyer's agent to perform their own diligent visual walkthrough inspection of the property. The goal is to discover material facts and identify any red flags that might necessitate further specialized inspections by licensed professionals.
So 2 sets of agent eyes on top of the buyer's inspector.
That's the idea. Agents must then disclose their findings in the designated section of the transfer disclosure statement or by attaching an agent visual inspection disclosure, or AVID. This is separate from, and in addition to, the buyer's hired home inspector's report, providing another layer of professional scrutiny.
Okay. What about warranties and insurance? How are they different?
A home warranty is a product offered by a private company distinct from insurance. It's designed to maintain, repair, or replace major home components and systems like appliances, electrical, plumbing, and HVAC for a specified period, typically 1 year. It covers normal wear and tear that regular hazard insurance doesn't.
Warranty, wear and tear on systems.
Right. Hazard insurance, on the other hand, is almost always required by lenders and covers loss or damage to improvements from disasters or accidents like fire, flood, or limb damage, but not general wear and tear. It's about protecting the physical asset from unforeseen major events.
Insurance to big disasters, accidents. Got it. What about environmental issues and other public controls that must be disclosed? This seems like an ever-expanding area of disclosure.
It absolutely is, and it's a critical component of informed real estate decisions. Let's start with indoor air quality. Concerns include the presence of chemicals, mold, volatile organic compounds, VOCs, from building materials, and the deadly odorless and colorless carbon monoxide, which is a byproduct of incomplete combustion.
Carbon monoxide, that's serious.
Extremely. California, in particular, requires carbon monoxide detectors in most residential properties, and sellers must disclose their existence on the TDS. The surprising fact here is how insidious and dangerous something like CO can be, precisely because it's undetectable by human senses without a monitor.
Makes sense to require detectors. What else? Lead paint.
Yes, lead-based paint. The Federal Residential Lead-Based Paint Hazard Reduction Act, commonly known as Title X, applies specifically to homes built before 1978. For these properties, sellers and landlords are legally mandated to disclose any known information about lead-based paint hazards, provide any available records, include specific warning statements in contracts or leases, and give the EPA pamphlet Protect Your Family from Lead in Your Home.
The lead pamphlet, right.
Home buyers also get a 10-day period for inspection, which can be waived. It's crucial to remember that, surprisingly, no federal law actually requires the owner to test for lead. The law only requires disclosure of known lead.
You only have to disclose what you know about lead, not test for it. Interesting.
It is. Termites are another common and costly concern in California. These tiny insects can cause major structural damage to wood components of a home, often going unnoticed for years until a swarm appears or significant construction damage is discovered.
In termites. Definitely want to know about those.
Certified inspectors look for Section 1 items, indicating current infestations, and Section 2 items, indicating conditions conducive to future problems like excessive moisture or wood-to-soil contact. Beyond the property itself, public controls require specific disclosure.
Like what? Zoning.
Yes, and if a property is near a public, private, or military airport, ancillary military facilities, or military training routes, or an industrial zone with manufacturing or commercial uses, these facts must be disclosed to the buyer. Similarly, properties located in specially regulated areas require disclosure on the Natural Hazards Disclosure Statement, or NHD.
NHD. What's covered there?
These areas include designated flood zones, high fire hazard severity zones, areas susceptible to wildland forest fires, and earthquake fault zones, as well as seismic hazard zones. California has a lot of these potential hazards.
Yeah, definitely. What's truly fascinating and often a very delicate topic is the concept of stigmatized properties and the incredibly fine line an agent has to walk regarding what they can and cannot disclose.
Stigmatized properties are those whose market value is suppressed, not due to any physical defects, but due to an unrelated, usually psychological or emotional event. This could be a property where a death, murder, suicide, or even suspected paranormal activity occurred.
Whoa. Ghosts.
Potentially, or just the knowledge of a past event. It might even be the site of a famous or infamous event. License holders are generally obligated to disclose these factors if they are known and could reasonably be considered to affect the property's value or desirability.
So, if it might bother a buyer, you probably have to disclose it.
The rule of thumb is, if it might reasonably impact a buyer's decision or the value, it should be disclosed. This is where it gets tricky, because it's not about physical damage, but human perception. However, there are very specific and critical limitations on what agents can disclose.
Like what? What can't they say?
For instance, regarding Megan's Law, which provides public access to information about registered sex offenders, agents should not disclose or investigate the presence of sex offenders in the area for a client. Their legal obligation is solely to alert buyers to the existence of the online registry where buyers can conduct their own research.
So, point them to the website, don't do the research for them.
Exactly. This is a crucial distinction to avoid potential discrimination claims against the agent. Furthermore, and this is absolutely critical, agents are legally prohibited from disclosing any information related to the status of federally protected classes.
Right, fair housing stuff.
Absolutely. This means you absolutely cannot disclose information about a person's race, color, religion, sex, sexual preference, national origin, familial status, or disability. This is strictly to prevent discrimination and ensure fair housing practices are upheld for everyone. It's a fine but critical line to walk to balance disclosure with anti-discrimination laws.
When an agent formally works with a buyer or seller, there's always a written agreement that defines that relationship. Let's unpack the basics of these agency agreements. What are they and why are they so crucial?
Agency agreements, sometimes also referred to as employment agreements, are truly foundational to the real estate profession. They are governed by both agency law and critically contract law. To be enforceable in California, these agreements must be in writing and signed by all parties involved.
Got to be in writing. Statute of frauds again.
Exactly. This isn't a suggestion, it's a legal requirement stemming from the statute of frauds. A key practical point is that they are not state promulgated, meaning the state doesn't provide a mandatory blank form. Instead, most brokers use forms from realtor associations or forms drafted by their own attorneys. Also, generally, an agency agreement is not assignable to another party without mutual consent.
Okay, different types.
Yes. These agreements can be classified in a few ways. They can be bilateral, where both parties are obligated to perform. Most exclusive agreements fall into this category and must have a specific start and end date. Or they can be unilateral, where only one party is obligated if the other chooses to act. Open agreements are typically unilateral and don't require specific dates.
Bilateral, 2 promises. Unilateral equals 1 promise.
Essentially, yes. The primary types you'll encounter are listing agreements between a seller and broker, buyer representation agreements between a buyer and broker, net listings, where the commission is based on what the seller nets, which we'll discuss, and option agreements, which include an option for the agent to purchase the property. Each has distinct implications for responsibilities and compensation.
What's absolutely paramount, and often the first step in these relationships, is agency disclosure. How does that process work, and why is informed consent so critical?
Agency disclosure is paramount because it means explicitly informing all parties whom an agent represents in a transaction. This prevents misunderstandings and potential conflicts of interest.
Everyone needs to know who works for whom.
Precisely. The underlying principles here are first substantive contact and informed consent. First substantive contact is the critical point where this disclosure is legally required generally, at the very first face-to-face meeting with a customer, before any confidential information is shared or specific property actions are initiated.
Before you get too deep into conversation.
Right. Informed consent means the client must fully understand the nature of the agency relationship, who the agent represents, and what that means for their duties, and then agree to it before it's formalized. In California, there are 2 specific forms that are required for this. Form AD, which is the disclosure regarding real estate agency relationship, and Form AC, the confirmation of real estate agency relationships.
Form AD and Form AC. Need those.
These forms ensure everyone is on the same page from the outset. While an agency relationship can be created in various ways, sometimes even by implication through actions, an agency agreement itself must be in writing to be legally enforceable.
Relationship versus agreement. Good distinction. How do these end?
As for termination, agency agreements can be discharged in one of 2 main ways. Either by operation of law, which means the contract ends due to legal application regardless of the party's desires, like if the property is destroyed by a natural disaster, or by acts of the parties, meaning the termination is a direct result of the actions or expressed intent of one or both parties, such as a mutual agreement to terminate. Understanding these termination pathways is as important as understanding how they begin.
Let's dive into the different types of listing agreements. How do these specific agreements impact commission and ultimately who gets to sell the property?
A listing presentation is typically an agent's initial pitch to a seller. During this, the agent presents a suggested price range, usually derived from a detailed comparative market analysis, CMA, and outlines their strategic marketing plan for the property.
The sales pitch.
Exactly. The listing agreement itself is essentially an employment contract between the seller and the broker. In California, these agreements must be in writing to be enforceable, though no specific state form is required. So many agents use forms from realtor associations like CRR. It's always good practice to provide signed copies to your clients.
Okay, what are the main types of listings?
There are several distinct types, each with different implications for commission. First, an open listing. This is non-exclusive.
Non-exclusive, meaning anyone can sell it.
Yes, multiple brokers and even the owner can simultaneously try to sell the property. Only the procuring cause, the one whose actions directly led to the sale, gets the commission. If the owner finds the buyer themselves, no commission is owed to any broker. These are typically unilateral contracts and don't require specific start-end dates.
Open listing sounds risky for the broker.
It can be. That's why the exclusive authorization and right to sell listing is the most common and preferred type by brokers, and often by sellers too, for its clarity. With this bilateral agreement, the named broker receives a commission if the property sells within the contract term, regardless of who found the buyer, even if the seller finds them.
So the broker gets paid no matter what if it sells during the term.
Correct. These must have definite start and termination dates to be valid. Then there's the exclusive agency listing.
How's that different?
It blends elements of both open and exclusive agreements. The seller agrees to list with only one firm, giving them exclusivity. However, if the seller finds their own buyer without the agent's assistance, they owe no commission to the broker.
So the seller can still sell it themselves and not pay commission.
Exactly. Like the exclusive right to sell, it's a bilateral contract and must have start and end dates. Next is a net listing.
Net listing. Sounds like it's about the seller's bottom line.
It is. It's defined purely by its compensation structure. The seller sets a minimum net amount they want to receive from the sale, and the broker's commission is any excess received above that price. These are legal in California, but often raise ethical questions due to potential conflicts of interest.
Yeah, seems like the broker might want to lowball the net to get a bigger commission.
That's the concern. Lastly, an option agreement, or more precisely, an option combined with a listing agreement, includes a clause giving the agent the option to be the buyer of the property at an agreed price, in addition to being the listing agent.
Whoa, the agent can buy the listing.
Yes, but there are strict disclosure rules around that. The eligibility for commission varies significantly across these types, reinforcing the importance of clear understanding and explicit agreement before signing.
Beyond just the type of listing, what are the specific clauses and obligations within both listing and buyer representation agreements that really protect both parties and prevent misunderstandings down the line?
For listing agreements, the legal requirements are quite clear. They must be in writing, signed by the seller, clearly identify the property with a legal description, and if they're exclusive or irrevocable, they absolutely must have a definite start and termination date.
Writing, signature, property ID, dates. Got it.
Common provisions typically include the names of the seller and broker, the broker's authorization to submit offers and list the property on the multiple listing service, MLS, the specific term of the listing, detailed compensation information, short sale disclosures if applicable, and seller representations about their legal right to sell and the accuracy of the information they provide.
What about protection for the broker after the listing ends?
An important provision for brokers is the protection period or safety clause. This extends the broker's right to compensation for a stated number of days after the listing agreement expires. However, it only applies if the property is sold to a buyer who was specifically introduced to the property by the broker during the original listing term and whose names were provided to the seller in writing before the listing expired.
So if the broker brought the buyer, they still get paid for a while after.
Correct, under those specific conditions. The Residential Listing Agreement, exclusive authorization and right to sell, from the California Association of Realtors, CAR, is the most widely used form for this. In terms of obligations, the broker's main duties are to diligently market the property and present all offers received to the seller.
Present all offers, even lowball ones.
Yes, unless the seller has given written instructions otherwise. The seller, in turn, is obligated to consider all offers, act in good faith, and make the property available for viewing by potential buyers. Interestingly, if an associate licensee enters into a listing agreement on behalf of their broker, the responsible broker can actually cancel that agreement within 5 days, allowing for a review period.
Broker gets 5 days to review their agent's listing.
It's an oversight mechanism. For disputes, these agreements typically stipulate that mediation will be attempted first as a less adversarial method before moving to more formal arbitration or court action.
Mediation before fighting. Good idea. What about buyer agreements?
Buyer representation agreements are similar employment contracts, but between a buyer and a broker. Legally, they also must be in writing, signed by the buyer, and have definite start and termination dates if they are exclusive or irrevocable.
Same basics. Writing, signature, dates.
Right. The broker's obligations include assisting the buyer in locating appropriate properties and financing, providing lists of qualified professionals for inspections, performing their own visual inspection of properties, providing and reviewing necessary forms, facilitating the transaction, and advising the buyer to use specialists when needed. The buyer's obligations include acting in good faith, providing timely proof of their ability to purchase, making written requests for material information or issues, and indemnifying the broker for certain actions. Both types of agreements are about setting clear expectations and responsibilities for a smooth transaction.
Moving from the agreements that define relationships to the actual property itself, how do we determine a property's value? It's clearly not just about what someone pays. There's a whole science behind it.
You're absolutely right. It's far more nuanced and complex than just the final sale price. We begin by revisiting the unique physical characteristics of real estate. Its immobility, it can't be moved, its durability or indestructibility, it can't be truly destroyed, and its uniqueness or non-homogeneity, no two parcels of land are exactly the same.
Immobile, indestructible, unique.
Okay. These inherent qualities profoundly influence value because they dictate supply and demand in a very fundamental way.
Now, this is where it truly gets interesting for anyone trying to understand value. The dust characteristics.
Right.
What does dust stand for, and what do they tell us about what makes a property valuable?
DOST is an excellent mnemonic for the four characteristics that fundamentally give a property value, regardless of its physical attributes. Demand.
People have to want it.
Exactly. Utility.
It has to be useful for something.
Right. Scarcity.
Less of it means it's worth more.
Correct. And transferability.
You have to be able to actually sell it.
Precisely. The property must be legally capable of being sold or conveyed to be of value. If there are legal impediments to its transfer, such as a cloud on the title, its value is significantly diminished. If you can't sell it, it's not truly valuable in a market sense. It's also vital to distinguish between market value price and cost.
Okay, what's the difference?
Market value is the theoretical selling price a property would achieve under typical, open, and competitive market conditions. What a willing buyer would pay a willing seller when both are informed and acting rationally. Price is simply the actual amount a buyer pays and a seller accepts in a specific transaction. It might or might not reflect the true market value.
Market value theory, price, reality.
In a way, yes. And cost is just the amount of money required to buy, build, or develop something without considering current market factors or the property's utility. The relationship between supply and demand is fundamental to real estate value.
High demand, low supply, prices go up.
Generally, yes. When demand for real estate is high and supply is low, property naturally becomes more valuable and prices tend to rise significantly. Conversely, low demand and high supply lead to falling prices. This dynamic also drives the concept of highest and best use, which is the most profitable legal use of a property, contributing significantly to its overall value.
Highest and best use, making the most money from it legally.
Correct. An appraisal is an official valuation by a licensed appraiser, resulting in an appraised value on a specific date. Assessed value is what governmental units use for calculating property taxes, and plottage refers to the increased value that can result from combining adjacent plots of land into a larger, more valuable parcel.
Beyond a formal appraisal, which is done by a licensed professional, how do agents estimate value for their clients, particularly sellers who are trying to price their home for the market?
This is precisely where the comparative market analysis, or CMA, comes in. A CMA is a report that real estate agents prepare by comparing the prices of recently sold homes, currently listed homes, and even properties with expired listings, all referred to as comparables, or comps, to estimate the market value of a specific subject property in the same area.
CMA, the agent's version of an appraisal, kind of?
Kind of, but it's crucial to differentiate it from a formal appraisal, which is performed by a licensed appraiser and is a more precise, official valuation used by lenders. A CMA is an agent's informed estimate, not a certified appraisal.
Okay, estimate, not appraisal. How do they pick the comps?
When selecting comparables, the gold standard is property sold less than 6 months ago. In slower markets, you might stretch to 12 months, but generally the more recent the better. You should aim for at least 3 comparables that are as similar as possible to the subject property.
Recently sold, similar properties. Makes
Yeah.
sense. What about houses currently for sale?
It's important to note that current listings and pending sales are not helpful comps for determining value, because their ultimate sales price is unknown. They haven't closed yet. They can, however, provide insight into current market competition.
Okay, so focus on the sold. How do they adjust for differences? Like if one comp has a pool and the subject doesn't.
When making pricing adjustments, you essentially look at recently sold homes that are identical in almost every way except for one feature. The price difference between those two homes can then be attributed to that single differing feature. For example, if 2 identical homes sold recently, but one had an extra bathroom and sold for $20,000 more, you could attribute that $20,000 value to the extra bathroom.
So you figure out the value of each feature by comparing.
Exactly. Once you have these adjusted comparable sales prices, you can establish a suggested listing price range for your client. This range typically starts at or just below your lowest adjusted comps value and ends at or just above your highest. Ultimately, however, the seller has the final say on the listing price.
Agent advises, seller decides.
Your role as an agent is to educate and guide them with data, not dictate the price.
Now, let's dive into the 3 main approaches to valuation that licensed appraisers use to arrive at that incredibly precise final number for a property's value. What are they, and when would each be used?
Absolutely. These are the methodologies appraisers employ, and choosing the right one depends heavily on the type of property and available data. First, the sales comparison approach, sometimes called the market data approach.
The one that uses comps, like the CMA.
Exactly,
Yeah.
but much more rigorously. This approach bases its valuation on local real estate market activity and is heavily relied upon for appraising owner-occupied residential properties and vacant land. It's rooted in two key principles. The principle of substitution, which states that a buyer won't pay more for a property than they would for a comparable substitute.
Right. Why pay more for the same thing?
And the principle of contribution, which means an improvement's value, is based on how much it adds to the property's market value, not just its original cost.
So a $50 K kitchen remodel might only add $30 K in value.
It could, depending on the market. To use this, appraisers collect data from recent sales of similar properties or comparables in the immediate area. The fundamental idea is comparable property sales price plus ACE adjustments, subject property value. Adjustments are made for differences in size, often using price per square foot, age, condition, and market conditions over time.
Okay, sales comparison for houses and land. What's next?
Second is the cost approach, also known as the summation or reproduction cost approach. This method estimates a property's current market value by determining how much it would cost to replace or reproduce the building and other improvements today, then subtracting any accrued depreciation and finally adding the value of the land.
Cost to build new minus depreciation plus land value.
Exactly. The simple formula is reproduction or replacement cost depreciation plus land value, property value. This approach is best for new construction or unique, specialized, or historical buildings like museums, libraries, or churches, where finding good, recent comparables for the sales comparison approach is often difficult or impossible.
So for weird or brand new buildings?
Generally, yes. It's important to differentiate replacement cost, the cost to build a similar new building using modern materials and design, providing similar utility from reproduction cost, the cost to create an exact copy of the original building, preserving its original styles and materials, which is often more expensive.
Replacement similar, reproduction exact copy.
Right. Depreciation is a reduction in value for any reason, and it's critical to factor it in because an older building is naturally less valuable than a brand new one with the same features. Undeveloped land, crucially, is not subject to depreciation. It's considered to retain its value.
Land doesn't depreciate.
Oh, okay.
Types of depreciation.
Yes. Types of depreciation include physical deterioration, simple wear and tear like a leaky roof, and obsolescence, loss of value due to economic or functional factors. Functional obsolescence is when a property's design or function is outdated or inefficient, like a single bathroom in a 5-bedroom house or an unusually poor floor plan.
Like having to walk through one bedroom to get to another.
That's a classic example. External or economic obsolescence is caused by negative outside forces beyond the owner's control, such as a nearby factory closing down, increasing crime rates, or a major highway being built adjacent to the property.
Stuff happening outside the property lines.
Correct. Depreciation can be curable, fixable at a reasonable cost like painting, or incurable, impossible to fix or not worth the expense like completely reconfiguring an outdated floor plan. We also use economic life, the period over which an improvement contributes value, and an age-like depreciation formula. Age and property, total useful life, appreciation percent, to calculate depreciation.
Okay, lots of factors in the cost approach. What's the third one?
The third approach is the income approach, or income capitalization approach. This method appraises real estate based on the income it generates, effectively converting that potential income into a value estimate. It's primarily used for income-producing commercial properties like shopping centers, office buildings, large apartment complexes, or industrial warehouses.
So this one's for investment properties.
Primarily, yes. It's strongly supported by the principle of anticipation, the idea that a property's present value is significantly affected by its anticipated future income or utility. The core formula for the income approach is the classic IRV formula. Net operating income, R, capitalization rate, R, value V.
I divided by R equals V. Income, rate, value. What's the cap rate?
The capitalization rate, or cap rate, is essentially the rate of return an investor can expect from a property. It's the percentage of expected annual income earned over a property's value. To arrive at the net operating income, NOI, you first need the potential gross income, PGI, which is the total rental income if the property were 100% leased with no vacancies.
PGI is perfect world income.
Right. From that, you subtract vacancy cost and add any other income, like laundry or vending, to get the effective gross income, EGI. Finally, NOI is EGI minus all operating expenses.
EGI minus operating expenses. NOI. What isn't an operating expense?
It's crucial to remember that operating expenses do not include debt service, like mortgage payments, as that's financing costs, not operating, or replacement reserves for major capital improvements. You can also manipulate the formula to solve for the cap rate. NOI, property value, or use simpler multipliers like the gross rent multiplier, GRM equals property price, annual rent income, typically for smaller residential income properties, or the gross income multiplier, GIM equals property price and total annual income for larger commercial properties.
GRM and GIM. Quick ways to compare income properties.
They can be, yes, for a rough comparison. To conclude, after applying one or more of these approaches, an appraiser performs reconciliation. This isn't just an average, it's a careful weighing of the relevance and reliability of each approach for the specific subject property to arrive at a final value estimate.
So they look at all the results and decide which makes the most sense.
Exactly. For typical owner-occupied residential homes, the sales comparison approach is almost always given the most weight. For new construction or highly unique properties with no direct comps, the cost approach is often best. And for income-generating commercial buildings, the income approach is generally preferred. Each approach offers a different lens, and reconciliation brings them into focus.
Beyond sales, a huge dynamic part of the real estate world is managing properties. What exactly does a property manager do, and what's their main objective when they take on that responsibility?
A property manager is a professional hired by a property owner to oversee the marketing, maintenance, and day-to-day operations of a rental property. This role can take a few forms: an individual property manager, who might manage multiple properties for different owners, an individual building manager for a single larger building, or a resident manager who lives on site to handle immediate needs.
Different types for different needs. Do they specialize?
Yes, property managers often specialize in residential, commercial, industrial, or even special-purpose properties due to the distinct needs and regulations of each. Despite the specialization, their main duties are largely consistent: effective marketing to attract and retain quality tenants, fostering positive tenant relationships, accurately setting appropriate rents, and ensuring their timely collection.
Collecting rent is a big one.
Huge. Drafting and enforcing comprehensive lease agreements, managing all aspects of facility maintenance and finances, and overseeing risk management and safety protocols to protect both the property and its occupants. The property manager's primary objective is twofold: to realize the highest possible financial return on the owner's investment, and, just as importantly, to enhance and preserve the property's value over time.
Make money and keep the property valuable.
That's the core mission. This involves creating a detailed management proposal outlining their strategy for achieving these goals for the specific property.
So how do property managers actually find tenants, set rents, and then keep track of all the money coming in and going out?
Finding quality tenants begins with a strategic marketing plan, carefully tailored to the property's specific vacancy rate and the local market. This plan includes a thorough market analysis, a budget for advertising, and specific marketing tactics, with a keen eye on calculating the cost per prospect, the cost of an advertisement divided by the number of prospects generated, to ensure marketing efficiency.
Got to be smart about advertising money. How do they pick tenants?
When evaluating prospective tenants, property managers use standardized lease applications to gather consistent information. It is absolutely crucial to adhere to the Fair Employment and Housing Act, FEA, in California, which strictly prohibits discrimination based on protected classes like race, religion, sex, disability, or familial status.
No discrimination. Very important. What can they look at?
However, managers can legitimately consider factors like a potential tenant's credit score, verifiable income, employment proof, criminal record, bankruptcy history, or past evictions, provided these criteria are applied uniformly to all applicants without bias. For financial oversight, a rent roll is an essential report.
Rent roll. Like a spreadsheet of tenants and payments.
Essentially, yes. It's a comprehensive document that lists all units, tenant identities, current lease terms, monthly income, and any outstanding balances. Maintenance generally falls into three critical categories: routine maintenance, regular tasks like cleaning and landscaping; corrective maintenance, repairs after something breaks down, like fixing a leaky faucet; and preventative maintenance, proactive inspections and actions to avoid major issues, like regularly inspecting HVAC systems.
Routine, corrective, preventative. Keep things running.
Exactly. Understanding income is vital for profitability. Potential gross income, PGI, is the theoretical maximum revenue if a property were 100% leased, with no vacancies. Effective gross income, EGI, accounts for vacancies and other revenue sources like laundry fees or parking. Net operating income, NOI, is EGI minus all operating expenses.
TGI, EGI, EGI, NOI. Gotta know the difference. Yep.
Crucial. It's important to remember that NOI specifically excludes debt service, like mortgage payments, and replacement reserves for major capital expenditures. Operating cash is calculated as income minus expenses minus debt service. Expenses are categorized as operating expenses day to day versus capital expenditures, CapEx, which are improvements that add value, like a new roof. Property managers must also maintain trust accounts, entirely separate from personal or operational funds, due to the fiduciary nature of their role, as mandated by Section 2831 of California law.
Just accounts again. Very important.
Always. They regularly produce various financial reports, including different types of budgets, capital reserve, budget comparison, stabilized, operating, and financial statements, profit and loss operating statements, to keep owners fully informed.
Let's delve into the specific laws governing landlords and tenants here in California. What are the key protections and obligations for both sides, and what happens when those laws are broken?
California has some of the most robust landlord-tenant laws in the country, designed to protect both parties. The California Tenant Protection Act of 2019 introduced two significant statewide protections. First, landlords must have just cause to terminate a tenancy, meaning they can't just evict without a valid reason.
Can't just kick someone out for no reason.
Right. Second, annual rent increases are strictly limited to 5% plus the local inflation rate, consumer price index, or 10%, whichever is lower. This provides critical stability for tenants. The Costa-Hawkins Rental Housing Act of 1995, on the other hand, exempts certain units from rent control regulations and allows rent to be reset to market rate upon vacancy, balancing tenant protections with landlord flexibility.
So state laws limit rent hikes and evictions, but Costa-Hawkins adds some exceptions.
Correct. Federal laws also play a significant role. The Americans with Disabilities Act, ADA, requires accommodations for persons with disabilities, impacting accessibility in public facilities, Title III, and employment practices, Title I. The Federal Fair Housing Act prohibits discrimination in housing based on race, color, religion, national origin, sex, disability, and familial status. These are the protected classes.
ADA and fair housing. Big federal laws.
Absolutely. Property managers can ask about credit score, income, employment proof, and eviction bankruptcy history, as long as these criteria are applied uniformly to all applicants without any discriminatory bias. The Protecting Tenants at Foreclosure Act, PTFA, ensures bona fide tenants receive at least 90 days notice before an eviction filing due to a property foreclosure.
90 days notice if the landlord gets foreclosed on.
Yes. A key tenant protection in California is the implied warranty of habitability, which is the landlord's fundamental obligation to provide and maintain livable conditions.
Habitability. The place has to be livable, right?
Right.
Safe and sanitary.
Exactly. If critical repairs aren't made within 30 days for non-emergencies, tenants have several options. They can withhold rent until repairs are made, repair and deduct costs from their rent, up to 1 month's rent twice in a 12-month period, sue for damages, report the issues to health inspectors, or even abandon the property if it's truly unlivable.
Tenants have options if the landlord doesn't fix things. What about security deposits?
Security deposit rules are also very specific. As of July 1st, 2024, the maximum security deposit a landlord can collect is 1 month's rent. It's explicitly not a non-refundable cleaning deposit. Any portion not used for legitimate repairs or cleaning beyond normal wear and tear must be returned.
Only 1 month's rent max now, and you get it back if you leave the place, okay?
Right. The landlord has a strict 3-week, 21 calendar days period to return any unused portion of the security deposit, along with an itemized statement of deductions. Landlords are also required to make numerous disclosures in California: lead-based paint, asbestos, meth manufacturing on the premises, the cause of death of a prior tenant if within 3 years, but not for AIDS-related deaths.
Wow, have to disclose if someone died there.
Within 3 years, yes, unless it was AIDS-related. Also, the existence of the Megan's Law sex offender registry, pesticides used or planned, proximity to closed military bases, condo conversion status, demolition permit applications, and flood hazard zones, among others.
Lots of required disclosures for landlords. What about tenants? What do they have to do?
Tenant obligations, in turn, include paying rent on time, keeping the unit clean and sanitary, proper waste disposal, correct and safe use of fixtures and common areas, adhering to reasonable rules, providing 30-day notice to vacate for month-to-month tenancies, and relinquishing keys upon departure.
Pay rent, keep it clean, follow rules, give notice.
Basically, yes. Failure to meet these obligations can lead to evictions or unlawful detainer actions through the courts. Importantly, landlord retaliation against tenants exercising their legal rights is strictly prohibited. It's a complex but essential framework designed to balance rights and responsibilities.
Finally, let's explore the actual agreements that formalize these landlord-tenant relationships. Property management agreements and leases. What are their essential components and how do they differ?
Most property managers are considered general agents, meaning they have broad authority from the owner to manage all affairs within specified areas of the property, including the significant ability to sign binding lease contracts on behalf of the landlord.
General agents. They can sign leases for the owner.
Correct. Property management agreements typically identify the parties, owner and manager, describe the property being managed, stipulate the contract period and detailed termination conditions, define the manager's precise scope of authority, state the owner's overarching purpose for the property, outline specific responsibilities for both parties, detail reporting requirements, specify management fees, and address crucial insurance provisions.
The contract between the owner and the manager. What about the lease itself?
Leases are formal, legally binding contracts. For a lease to be valid in California, it must be in writing if it's for more than 1 year due to the statute of frauds. It must clearly contain the names of the parties, the lessor or landlord, and the lessee or tenant, a clear property description, the definite start and end dates of the agreement, the specific rent rate and payment method, and importantly, any automatic renewal provisions must be clearly bolded for transparency. All parties entering the lease must, of course, be legally competent.
Writing if over a year. Names, property, dates, rent, bold renewals. Got it. Different kinds of leases.
Yes, leases establish different leasehold estates defining the nature of the tenancy. An estate for years has a specific fixed start and end time. It does not automatically renew, and no notice is required for termination at the end of the term.
Estate for years, fixed term, ends automatically.
Right. An estate from period to period, or periodic tenancy, has a fixed period, like month to month or year to year, that automatically renews until either party gives proper notice to cancel.
Periodic auto-renews. Needs notice to end. Most common.
Very common, especially month to month. An estate at will allows a tenant to occupy with the landlord's consent, but without a formal agreement or definite end date. Either party can terminate it at any time with proper notice. An estate at sufferance occurs when a tenant remains beyond their lease terms without the landlord's consent, essentially becoming a holdover tenant. This is the least secure type of tenancy.
Holdover tenant. Not good. What about other lease terms?
Key lease provisions also include security deposit rules, as noted, max 1 month's rent as of July 2024, not for cleaning, returned within 3 weeks. Landlord entry typically requires prior notice and tenant permission, upholding the tenant's fundamental right to quiet enjoyment. Assignment means the original tenant transfers all of their rights and obligations to a new tenant, the assignee, but the original tenant typically retains secondary liability if the assignee defaults.
Assignment, new tenant takes over completely, old tenant still back up liable.
Usually, yes. Subletting means the original tenant, sublessor, partially transfers their interest to a sublessee, but the original tenant remains primarily liable to the landlord in what's sometimes called a sandwich lease.
Sublet, old tenant still primarily responsible. Okay, how can leases end early?
Early termination of a lease can occur due to a breach of contract by either party. A.g., landlord's failure to provide habitability, tenant's unauthorized use or abandonment, breach of a specific condition. Or it can occur without breach due to events like property destruction, mutual agreement to terminate, operation of law, or for victims of domestic violence who need to give notice and pay 14 days rent, for example.
Okay, last thing on leases. Different ways rent is calculated.
Finally, leases based on rent structure include a gross lease, where the tenant pays a fixed monthly rent and the landlord covers all operating expenses, like property taxes, insurance, maintenance.
Gross lease, landlord pays expenses. Simple for tenant.
Right. A net lease, where the tenant pays a base rent plus all or part of the operating expenses. This can be single net, double net, or triple net. A single net lease means the tenant pays base rent plus property taxes. A double net adds insurance premiums, and a triple net lease means the tenant pays base rent plus taxes, insurance, and maintenance, making them responsible for almost all property expenses.
Triple net tenant pays almost everything. Common for commercial.
Very common for commercial. A percentage lease, common in retail, where the tenant pays a base rent plus a percentage of their gross business profits, encouraging the landlord to help the tenant succeed. and a step-up lease, where the base rent increases incrementally at predetermined intervals over the lease term, providing predictable rent escalations.
To truly understand real estate, you need to know the basic anatomy of a house. Let's look at some common structures and styles that you'll encounter.
Understanding construction basics provides incredibly valuable insight into a property's integrity, its potential issues, and even its resale value. Common home styles you'll encounter include the ranch home, which is typically one story, often sprawling, the split level, characterized by staggered floor levels, often well suited for sloping lots, the 1.5 story, which has a smaller, often unfinished or partially finished upstairs area within the roofline, and the classic multi-story home featuring 2 or more full stories.
Ranch, split level, story and a half, multi-story. Okay, what holds it all up?
Ah,
Foundation.
Exactly. The foundation is absolutely critical. It's the structure that connects the entire building to the ground, designed to transfer all the loads from the house down to the earth. Key components include the footing, which is the underground base that spreads the load, the foundation wall, which forms the sidewalls for basements or supports a slab, the slab, which is a concrete base poured directly at ground level, and piers or piles, which are concrete or masonry columns used to support the structure, often in areas with specific soil conditions.
Footing, wall, slab, piers.
I got it.
Common types.
Common foundation types are slab on grade, most common in California, basement, and crawl space. The framing is essentially the house's skeleton, typically made of wood or steel.
The bones of the house.
Precisely. You'll encounter different framing types. Post and beam, an older, sturdy method with fewer, larger structural members. Balloon framing, where exterior wall studs run continuously from the foundation to the roof. And the most common modern method, platform framing, where each story is built as a complete platform, providing stability for the next story.
Platform framing. Build one floor, then the next.
Yeah.
It's common now.
Yes. For roof framing, rafters are the sloped internal beams that extend from the eaves to the central roof ridge beam. The pitch is the roof's steepness, expressed as the vertical rise divided by its horizontal run. Other important roof parts include the eaves, the overhangs, frieze boards, soffits, underside of the eaves, fascia boards, facing of the eaves, and flashing, material installed to prevent water penetration at joints. All these elements work in concert to provide structural integrity and protection.
Beyond the sheer structure, what are the vital major systems that make a home truly functional and comfortable? These are the unsung heroes of daily life in a house.
You're right, these are the true workhorses. The major systems are what make a house livable: HVAC, plumbing, and electrical. HVAC stands for heating, ventilation, and air conditioning. Ventilation is crucial for indoor air quality. It removes contaminants, controls moisture, and brings in fresh air. Systems can be supply-only, exhaust-only, balanced, or spot ventilation, like a bathroom fan.
Gotta have fresh air? What about heating?
Heating systems commonly use furnaces or boilers. Types include steam, hot water, hydronic, radiant, heat from floors, walls, and forced air systems, which are the most common in the U.S., distributing heated air through ducts. For air conditioning, units essentially transfer heat from the interior to the exterior of the house. They can be cooled by water, air, or a hybrid system.
AC just moves heat outside.
Essentially. Heat pumps are increasingly popular, energy-efficient alternatives in moderate climates. They can both heat and cool by moving heat rather than generating it. HVAC capacity is measured in British thermal units, or BTUs, which indicates the amount of heat a system can add or remove.
BTUs. Bigger number, more power. Plumbing.
Plumbing systems have 2 main critical purposes: bringing clean, potable hot and cold water into the house through supply lines, which require pressure, and efficiently draining wastewater and sewage out to either a municipal sewer system or a private septic system. Incoming water relies on supply lines and pressure, while outgoing water uses gravity-fed wastewater drainage systems.
Water in, water out. Important parts.
Important components include plumbing vents, which provide crucial airflow for drainage and release toxic sewer gases safely through the roof, and drain traps, those U-shaped pipes under sinks, which hold a small amount of water to create a seal, preventing sewer gas from entering the home.
That U-pipe stops sewer smells. Good to know.
Yeah.
Electrical.
The electrical system brings power from the utility provider to every outlet, light fixture, and appliance in the home. To prevent overload and fires, homes use either circuit breakers, which are automatic switches that stop current when there's an overload, or older fuses, which contain a metal wire that melts and breaks the circuit. Common wiring materials include copper, which is the standard, and aluminum, found in some older homes.
Breakers are better than fuses, generally.
Generally safer and more convenient, yes. Finally, it's vital to know that California contractors' license law requires licensing from the contractor's state license board for most construction work. Performing unlicensed work carries criminal penalties. There are exceptions, of course. Work costing less than $500, labor and materials combined, homeowners doing their own work on their primary residence, certain agricultural properties, oil and gas operations, and public utility work are generally exempt. This ensures safety and professionalism in construction.
Real estate transactions are built on contracts. What exactly makes a contract valid and legally binding, and what are the essential ingredients for that to happen?
Understanding contracts is absolutely fundamental to navigating real estate. For a contract to be legally valid and binding, it must unequivocally possess 5 essential elements. First, there needs to be mutual assent, also widely known as offer and acceptance. This signifies a clear meeting of the minds where both parties fully agree to the exact same terms, exchanging promises with complete understanding.
Offer and acceptance. Meeting of the minds. Okay.
Second, consideration, which is something of value exchanged by each party. This demonstrates their serious intent and agreement to the terms. It's not just money, it could be a promise to act, a promise not to act, or a tangible item.
Something of value exchanged.
Third, the parties must be legally competent, meaning they have reached the age of majority, 18 in California, and are not mentally incompetent or otherwise incapacitated. Fourth is reality of consent.
Reality of consent. Meaning?
Right. Meaning the parties must enter the contract of their own free will, with full and accurate information and without any duress, unlawful coercion, undue influence, or fraudulent misrepresentation. And fifth, the contract must have a lawful objective. It cannot involve or require any illegal activities or outcomes.
Mutual assent, consideration, competent parties, reality of consent, lawful objective, 5 essentials.
Those are the keys. Once created, contracts fall into 4 legal categories. A valid contract possesses all 5 essential elements and is fully legally binding and enforceable. A void contract lacks legal force from the very beginning. It was never a contract in the eyes of the law, perhaps because it had an illegal objective or lacked competence.
Void never was a contract.
Right. A voidable contract is one where a wronged party has the option to either enforce or void the contract, such as a contract entered into by a minor or under duress. And finally, an unenforceable contract cannot be enforced in court due to a legal technicality, even if it has the essential elements. For example, a real estate contract that wasn't put in writing when legally required by the statute of frauds.
Voidable. One party can cancel. Unenforceable, good on paper, but can't sue over it.
Exactly. It's a good contract in theory, but you can't make it stick in court.
What are the key restrictions on contract enforcement, especially here in California? It sounds like there are deadlines and specific requirements that can invalidate an otherwise good agreement.
You're absolutely right. In California, several principles can severely restrict contract enforcement, even if all the essential elements were initially present. The statute of frauds is paramount. It requires certain contracts, including most real estate contracts, such as purchase agreements, long-term leases, and real property transfers, as well as agreements not to be completed within 1 year, to be in writing, to be enforceable.
Statute of frauds, get it in writing for real estate.
Absolutely critical. Without written proof and signatures, such oral contracts cannot be legally upheld in court, which is a common pitfall. Then there's the statute of limitations, which sets specific time limits for bringing legal actions or lawsuits.
Time limits to sue. How long in CA?
For instance, in California, actions based on oral contracts typically have a 2-year limit, while those for fraud or mistake generally have 3 years, or 1 year after discovery of the fraud, whichever is later. Actions based on written contracts or their breaches typically have a 4-year limit, with the clock starting at the date of the breach.
2 years oral, 3 fraud mistake, 4 written.
Okay. If you wait too long to file a lawsuit, your right to sue is permanently lost, regardless of the merits of your claim. The doctrine of laches is closely related to the statute of limitations, but relies more on the court's discretion.
The laches. Sounds like lateness.
Essentially, yes. It's basically a use-it-or-lose-it rule. If a plaintiff has waited an unreasonable amount of time to make a claim, and that delay has unfairly prejudiced the other party, the court might bar the claim, even if the statute of limitations hasn't technically run out. It's about fairness and preventing surprise claims.
So don't sleep on your rights.
Pretty much. Lastly, regarding voidable contracts with minors in California, a person who entered a contract as a minor, under 18, can disaffirm that contract within a reasonable time after turning 18. Crucially, the other party to the contract cannot disaffirm it. It's a protection for the minor. Conversely, after reaching 18, a former minor can choose to ratify the contract, making it fully binding on them. These restrictions are designed to promote fairness and clarity in contract law.
How do offers actually become contracts in real estate, and what are the crucial aspects of modifying them once they're already in place?
The journey from offer to contract centers on offer and acceptance. The offerer is the party making the offer, for example, the buyer, and the offeree is the party receiving it, for example, the seller. The offeree has four fundamental options. They can accept the offer unconditionally, make a counteroffer, reject the offer, or simply ignore it.
Accept, counter, reject, ignore.
An acceptance must be absolutely unconditional and mirror the original offer perfectly. Any slight alteration, even a minor change to a term, transforms it into a counteroffer, which effectively rejects the original offer and creates a new one.
Counteroffer kills the original offer.
Yeah.
Important.
Very important. The original offer dies with a counteroffer. A critical clause, especially prevalent and important in real estate contracts, is time is of the essence. This means that all parties must perform their contractual duties and meet their specific deadlines by the date and time specified in the contract to avoid being in breach.
Time is of the essence. Deadlines matter. Big time.
Absolutely. For real estate license holders in California, their role in contract preparation is quite limited and specific. They are legally permitted to fill in blanks on prepared contracts, typically those drafted by lawyers or standardized forms from realtor associations. However, they are strictly not permitted to draft their own contracts from scratch or significantly alter the pre-printed legal language, as that constitutes the unauthorized practice of law.
Fill in the blanks. Don't write the contract.
And don't give legal advice. Similarly, while agents can explain factual statements or business details within the contract, they cannot provide legal advice. They can tell you, here's what this phrase means in a business sense, but not, here's what you should do legally. That's the attorney's role.
Explain. Don't advise legally.
Yeah.
Okay. How do you change a contract once it's signed?
When it comes to modifying existing contracts, an addendum is an addition of supplementary information that becomes part of the original contract without changing the original terms, just adding to them. An amendment, on the other hand, is a change or modification to an existing, already agreed-upon contract.
Addendum adds, amendment changes. Both need signatures.
Both must be dated and signed or initialed by all parties involved to be legally binding. In California, a unique and sometimes complex situation arises with multiple counteroffers. In this scenario, a seller might issue identical counteroffers to multiple interested buyers.
Whoa, seller can counter multiple buyers at once.
Yes. Both buyers can potentially accept, and then the seller reviews both accepted offers and selects which one to proceed with. The seller multiple counteroffer, SMCO form, is specifically designed for this, requiring specific signatures from both seller and buyer at different stages to become binding.
SMCO form. Sounds like it needs careful handling.
Very careful.
Finally, how are contracts discharged or terminated? And what are the implications when things don't go according to plan and a contract is broken?
Contracts can be discharged in two broad categories. By operation of law, meaning legal principles terminate it regardless of the party's desires. Think of something like a natural disaster making performance impossible, a force majeure event, or bankruptcy. Or by act of the parties, which involves the actions or expressed intent of at least one party, such as mutual agreement to terminate.
Ends by law or ends because the people involved did something?
Right. More specifically, contracts can be discharged through performance, ideally full and complete performance where all terms are met. Sometimes substantial performance, good enough for the purpose, can be deemed sufficient. If performance becomes impracticable due to unforeseen burdens, often called commercial frustration, or truly impossible due to an event occurring after the contract's execution, like destruction of the property, it can also lead to discharge.
Performance, impossibility.
Other common methods include expiration if a set date passes, or the statute of limitations being exceeded, where the legal right to sue is lost. A contract can also be discharged if it was lacking an essential legal element from its inception, if it's found to be an unconscionable contract with terms that are too one-sided or unfair, or if a specific force majeure clause in the contract is triggered by an unforeseen act of God.
Lots of ways out. What about death? Does that end a real estate contract?
Sure. Notably, death or incapacity of a party usually does not relieve contractual obligations in real estate, unlike personal service contracts, meaning the estate is still bound. Bankruptcy of a party often discharges contracts. Mutual rescission is when both parties agree to terminate the contract and return to their pre-contract positions as if it never existed.
Mutual rescission, hit the undo button.
Pretty much. Novation involves replacing an existing contract with a completely new one, which can involve new parties or entirely new terms. Accord and satisfaction means the parties agree to discharge the original contract with a new, often lesser, performance. For example, seller accepts the earnest money as full compensation instead of forcing the sale. A subsequent modifying agreement simply alters specific terms of the original contract while keeping it in force.
Novation, new contract replaces old. Accord and satisfaction, agree to accept less.
Correct. Finally, revocation, when a principal revokes an agent's authority, or renunciation, when an agent renounces their authority, can end an agency contract. Contingency clauses also provide clear termination points if their conditions aren't met, such as a financing contingency, buyer can't get a loan, or an inspection contingency, unacceptable defects found.
Contingencies are exit ramps. What if someone just breaks the contract? Breach.
Lastly, a breach occurs when a party fails to perform their obligations without legal cause, terminating the defaulting party's rights but maintaining their obligations. In California, if a seller breaches a contract for real property, buyers can often pursue specific performance, a legal remedy forcing the sale because each piece of real property is considered unique, and money alone often can't fully compensate for its loss unless the contract explicitly agreed to liquidated damages as the sole remedy.
Specific performance court makes them sell or buy. Because houses are unique.
Exactly. For a buyer's default, the seller's exclusive remedy is often specific performance. Unless liquidated damages are explicitly agreed upon, typically capped at 3% of the purchase price for a 1-4-unit dwelling the buyer intends to occupy, with any excess funds returned to the buyer. This clause defines the liquidated damages versus seeking compensatory or actual damages through a lawsuit.
Liquidated damages agree up front what the penalty is if buyer defaults, usually the deposit up to 3%.
Precisely.
We've talked about contracts generally, but let's narrow in on the purchase contract, the absolute centerpiece of any real estate sale. This is the document that orchestrates the entire transaction.
You're absolutely right. The purchase contract is truly the blueprint for a real estate transaction, meticulously outlining the responsibilities, terms, and conditions for both the buyer and the seller. In California, there is no single state-mandated form that everyone must use, but the California Association of Realtors, CAR, Residential Purchase Agreement, and Joint Escrow Instructions, or RPA, is by far the most commonly used form.
The RPA. Everyone uses that one.
Pretty much. It's quite unique because it serves simultaneously as the buyer's initial offer, and once the seller provides an unqualified acceptance and that acceptance is formally communicated to the buyer, it then transforms into the completed, legally binding contract. It's a single document with multiple functions.
Offer becomes contract upon acceptance. Efficient. Who writes it?
It's crucial to remember that all complex contracts, including these purchase agreements, are ultimately written by lawyers. While real estate agents are authorized to fill in the blanks and check boxes on these prepared forms, they are not permitted to draft their own contracts from scratch or significantly alter existing ones, as that legally constitutes the unauthorized practice of law.
Again, fill in blanks, don't draft, don't give legal advice.
Exactly. Similarly, while agents can explain the factual statements or business details contained within the contract, they cannot provide legal advice. They can tell you, here's what this specific paragraph means in terms of the transaction, but they cannot tell you, here's what you should do legally. That's the attorney's role.
So, what must be in a California purchase contract to make it enforceable, at a minimum? And then what are the typical inclusions we see beyond those absolute essentials that fill out the entire document?
According to a California Supreme Court ruling, there are only 4 essential elements strictly necessary for a purchase contract to be enforceable. These are the precise identities of the seller and buyer, ensuring full legal names are used and spelled correctly, a clear identity of the property with a unique description, like a legal description or street address, the agreed-upon purchase price, and finally, the time and manner of payment.
Who, what, how much, and when how paid. The bare bones.
If any of these absolutely fundamental elements are missing, the contract could be voidable or even void. Beyond these bare essentials, typical provisions in a comprehensive purchase contract are extensive and include detailed broker information and agency disclosures, a clear definition of what personal property is included, inclusions, or explicitly excluded from the sale.
Which appliances stay, which go.
Exactly. Precise details about the closing, which in California officially occurs when the deed is recorded at the county recorder's office, which is when ownership legally transfers, and the terms of possession, specifying the exact date and time when the buyer gets the keys and takes occupancy. Finance terms are always a material fact and must be fully disclosed within the contract. There's also the earnest money deposit, which is customary and demonstrates the buyer's serious interest, though surprisingly, it's not legally required for a valid contract.
Earnest money isn't required. Huh. But everyone does it.
It's strong evidence of good faith. The contract also allocates various closing costs between the buyer and seller and mandates statutory disclosures, such as lead-based paint information for homes built before 1978. The buyer's investigation and due diligence period is a critical time frame, often called the inspection period or option period. This grants the buyer a specified time to thoroughly investigate the property and learn all relevant information.
The inspection period, buyer's chance to check everything out.
Right. An as-is clause, common in California, means the buyer accepts the property in its visible current condition, but it never negates the seller's legal duty to disclose all known material facts about the property. The time is of the essence clause reiterates that all parties must meet their strict deadlines.
As is doesn't mean seller can hide problems they know about.
Absolutely not. The contract also carefully outlines default scenarios. If the buyer defaults, they generally stand to lose their earnest money deposit to the seller. The seller can also sue for specific performance, forcing the buyer to purchase, or for damages, though a liquidated damages clause, common in California for 1 to 4 unit owner-occupied dwellings, caps the amount the seller can keep from the earnest money to 3% of the purchase price, with any excess returned to the buyer.
Buyer default, seller likely keeps deposit, up to 3%.
If the seller defaults, the earnest money is returned to the buyer, who can also sue for specific performance, forcing the seller to sell, or for damages. Contingencies are crucial provisions that make performance conditional upon certain events occurring, like obtaining financing, a satisfactory inspection, or the sale of the buyer's current property. They clearly state the conditions under which the contract can be terminated without penalty.
Contingency is those safety nets again.
Exactly. The contract will also include references to relevant addenda and mandated forms. Electronic signatures are generally acceptable and legally binding. Amendments are specifically for making changes after the initial contract has been signed and accepted.
Are there other types of purchase contracts or options beyond the standard sale we typically see every day?
Yes, there are a few important variations that offer different structures for property acquisition. One is the contract for deed, also widely known as an installment sale or land contract. In this arrangement, the buyer pays the seller in installments over an agreed period of time, and the seller retains the deed and legal title to the property until the full purchase price has been paid.
Contract for deed, seller financing basically. Seller keeps title till paid off.
Essentially, yes. It circumvents traditional lenders. Another is the option to purchase, which is a unilateral contract. The potential buyer pays an option fee for the exclusive right, but not the obligation to buy the property at a certain price within a specific time frame. The seller, for their part, agrees to keep the property off the market for that period.
Option, pay for the right to buy later, but don't have to.
Correct. This is often used by developers or investors who want to secure a property while they perform extensive due diligence or seek financing without committing to the purchase upfront. If the buyer doesn't exercise the option, they lose the fee. And then there's the lease with option to buy, or lease option agreement.
Rent to own, kind of.
Similar concept. This combines a standard lease agreement with an option to purchase. The buyer leases the property for a specified period, typically a year or two, and then has the option to buy it, with the purchase terms, including the price, usually specified directly in the lease. A portion of the rent paid during the lease period might even be credited towards the purchase price if the option is ultimately exercised. Each of these options offers distinct financial and legal structures for property acquisition that can suit different needs.
Now, let's do a brief walkthrough of the California Residential Purchase Agreement, or RPA itself, highlighting the practical takeaways for our listener. It sounds like it's a truly multifaceted document that everyone needs to understand.
It really is, and understanding its practicalities is essential for anyone involved in a California real estate transaction. The California Association of Realtors Residential Purchase Agreement and Joint Escrow Instructions, or RPA, is incredibly comprehensive and plays multiple roles simultaneously. It serves as the initial offer to purchase, transforms into the completed contract upon acceptance, acts as a receipt for any earnest money deposited, provides joint escrow instructions to the escrow holder, incorporates a mediation and arbitration agreement, confirms agency relationships for all parties, and even acts as an irrevocable assignment of compensation to the brokers involved.
Wow, it does a lot of T. Offer, contract, receipt, instructions, agreements, all in one.
It's a single document designed to cover nearly every aspect. Practically, as an agent, you'll spend most of your time carefully filling in the blanks in paragraph 3 with the specific terms of the offer and checking the relevant addenda boxes in paragraph 4. The rest of the document provides detailed legal text that serves as a robust framework and reference. Key practicalities within the RPA include offer expiration.
Default is 5 p.m. on day 3, but customizable.
Right. This default with customization applies to most other deadlines in the contract. Initial deposit, earnest money. This is typically required to be wired within 3 business days of acceptance, though increased deposits are rare, usually aiming for about 3% of the purchase price to meet liquidated damages caps. Escrow. In California, escrow officially closes when the deed is recorded at the county recorder's office. This is the moment when legal ownership transfers from seller to buyer. The process typically takes 30 to 60 days.
Closing deed recorded, 30-60 days typical. Contingencies.
Critical protections like inspection or financing contingencies typically have a default removal period of 17 days after acceptance or 5 days after receipt for seller documents, whichever is later. Possession. This usually defaults to the exact moment title is recorded, but the contract allows for specific arrangements if a tenant is involved or the seller needs to remain in the property after closing.
Possession usually happens right when it closes. Home warranty.
The RPA covers details for a home warranty plan, which covers repair or replacement of systems and appliances post-possession. The buyer picks the plan, and the seller pays up to an agreed amount, with the buyer covering any difference. Property condition. The property is delivered as is unless otherwise agreed upon, but it's absolutely crucial to remember that this clause never negates the seller's duty to disclose all known material facts about the property via the transfer disclosure statement.
As is, but still got to disclose. Maintenance.
The property should be delivered with typical maintenance performed, and the seller is responsible for removing all debris and personal property not included in the sale by the close of escrow. If a seller remains in the property after COE, both parties should consult their insurance and legal advisors for liability and to create a formal written agreement. At a close of escrow, the seller assigns any warranties for systems appliances to the buyer and delivers all keys, passwords, and security system codes.
Seller clears out, assigns warranties, hands over keys. What if the buyer needs to sell their house first?
Sale of buyer's property contingency. The default in the RPA is that the sale is not subject to the buyer selling their own home. If this contingency is desired, a specific box must be checked and a separate form attached. Final walkthrough. This is the buyer's last chance to verify the property's condition and ensure agreed-upon repairs have been made, but it is not a contingency for new information or negotiation.
Walkthrough, final check, not renegotiation.
Correct. Time is of the essence. This critical clause applies to the entire contract, meaning all deadlines are strict. Liquidated damages. If a buyer defaults on the contract, the seller keeps the earnest money deposit as liquidated damages. For a 1-4-unit dwelling where the buyer intends to occupy, this is legally capped at 3% of the purchase price, with any excess earnest money returned to the buyer. Mediation. Parties agree to attempt mediation for disputes before pursuing arbitration or court action, encouraging amicable resolution.
Okay. Any really unique California points in the RPA?
And here's a crucial, truly California-specific point. California is the only state where parties must complete a specific contingency removal form, either a buyer contingency removal or a seller contingency removal form, to formally and legally lift contingencies and indicate they are moving forward in the transaction.
Wow, only CA requires a separate form to remove contingencies. That's huge.
It is a critical, unique step in the California real estate process that can't be overlooked. Forgetting it can cause major problems.
Moving from theory to practical application, how do agents actually find clients and market properties effectively and, just as importantly, ethically in today's digital age?
This is where the rubber meets the road for agents. It involves 2 primary activities: prospecting, which is actively finding new clients, and often farming, which means focusing their marketing and outreach efforts on a specific neighborhood or geographic area to cultivate leads over time.
Prospecting, hunting, farming, cultivating. Okay. Any rules on how they reach out?
Absolutely. Their outreach efforts are heavily regulated, particularly by federal laws. The Telephone Consumer Protection Act, TCPA, strictly governs telemarketing calls and unsolicited faxes or voice messages. A key provision is the Do Not Call registry. Agents must remove registered phone numbers from their call list within 31 days of checking the registry, and they are required to search and update their list quarterly. Calls are restricted to between 8 a.m. and 9 p.m. local time.
Do not call rules. Got to check the list, call at reasonable hours. Exceptions.
There's an established business relationship exception, allowing calls for up to 18 months after a consumer's last transaction or 3 months after a consumer's inquiry. But if a consumer requests removal, it must be done immediately, regardless of any prior relationship. For commercial email advertising, the CAN-SPAM Act dictates strict rules.
Canned spam for emails. What are the rules there?
Commercial emails must include an easy-to-use opt-out option, which must be honored within 10 business days. They also require a valid physical postal address for the sender and must clearly identify the message as an advertisement. They strictly prohibit misleading header content or subject lines and sending undesired messages to wireless devices.
Opt out, real address, identify as ad, no misleading stuff. Got it. Anything else on ethics and outreach?
These regulations are designed to protect consumers from unwanted and deceptive solicitations across different channels. Agents must also be acutely aware of and actively combat implicit bias in their practice to ensure fair and equitable service to all, making sure their marketing isn't inadvertently excluding or favoring specific groups.
What goes into a truly successful listing presentation? A comprehensive marketing plan, and even a seemingly simple open house that makes it effective, engaging, and ethical for everyone involved.
For a successful listing presentation, meticulous preparation is key. An agent must thoroughly research the property, gathering its legal description, plat map, tax records, and ownership history, visit the property in person to note its unique features and condition, create a detailed comparative market analysis, CMA, to suggest an accurate price range, and develop a comprehensive marketing plan.
Research, visit, CMA, marketing plan, homework first. What do they bring to the meeting?
When meeting the seller, they should bring the CMA, the proposed marketing plan, the blank listing agreement form, a net sheet, which estimates the seller's likely take-home profit after all costs, and a professional handout about themselves and their brokerage. The marketing plan itself, which absolutely requires seller consent, outlines where, when, and how the property will be effectively marketed. Its core goal is to secure another party, a buyer.
Marketing plan needs seller sign-off. What's usually in it?
Key elements include ensuring a prominent appearance on the multiple listing service, MLS, widespread website listings, strategic social media promotion, attractive yard signs and flyers, targeted print advertising, professional prepping and staging advice, and well-organized open houses and private showings. For MLS listings, quality is paramount. Staging the home, hiring a professional photographer, including a multitude of high-quality photos and neighborhood photos, and considering a virtual tour can make a huge difference.
Good photos are key for MLS yard signs.
Yard signs are excellent for advertising the property and the agent, but always require explicit homeowner permission for placement and any changes, like adding an in-contract banner.
So with all these digital tools, what about the ethics of advertising, especially regarding digitally enhanced photos? Where's the line?
That's a critical question in today's visual-heavy market. The Federal Trade Commission Act's truth in advertising provisions are paramount here. All advertising must be truthful, non-deceptive, backed by evidence, and fairly represent what's being sold.
Truthful, not deceptive, provable. Okay. What about photoshopping pictures?
When it comes to digitally enhanced photos, there are important nuances to navigate ethically. Virtual staging, where furniture is digitally inserted into an empty room, is generally accepted, as it helps buyers visualize the space without misrepresenting its physical structure.
Virtual staging, okay.
Cosmetic editing, like removing minor clutter, fixing a slightly crooked picture, or using blue sky or green grass filters to enhance lighting, is also broadly accepted, as it's seen as correcting minor imperfections or enhancing presentation without fundamentally altering the property.
Minor touch-ups, okay, what's not okay?
However, heavy alterations that make the house look significantly different from reality or misrepresent its value, like digitally removing a power line, adding a pool that isn't there, or changing structural elements, are considered unethical and potentially illegal. Ethical agents absolutely avoid making any changes that affect the property's material value or condition and always disclose significant image alterations. For example, by stating a photo is virtually staged,
Right.
or that certain elements are artists' renderings.
Don't make it look like something it's not, and disclose alterations. Got it. price again.
Regarding the listing price, remember, the agent's role is to educate and guide the client based on their CMA and deep market knowledge. However, the client ultimately makes the final decision on the listing price. For an open house, meticulous planning is key.
Open house tips.
Choose a day and time that avoid major holidays or conflicts. Advertise widely online and in local papers. Prepare comprehensive informational packets for visitors, including detailed home info, other relevant listings, and the agent's business card and bio. Ensure the house is thoroughly prepped and professionally staged. Place clear directional signs, always checking local zoning ordinances first. Use a guest log to capture visitor information. Stay present at the property to answer questions, and always follow up diligently with attendees afterward with a thank you note or relevant information. Every step needs to be transparent and well executed.
So we've journeyed through the intricate landscape of California real estate, from the very foundations of property ownership and the unique characteristics of land, to the complex world of contracts and the nuances of client relations. This deep dive is truly aimed to equip you with the essential knowledge needed to navigate this dynamic field, giving you a comprehensive overview of so many crucial topics.
Understanding these core concepts is so much more than just preparing for an exam. It's about empowering you to make truly informed decisions, protect your interests effectively, and comprehend the multifaceted nature of real estate transactions that touch everyone's lives.
Right.
Critical thinking, as always, is your absolute best tool for applying this knowledge in the real world.
As you reflect on our discussion today, what stands out to you as the most surprising or impactful insight? Perhaps it's how much the legal definition of property encompasses, or the specific regulations like that contingency removal form that protect both buyers and sellers. Think about how these rules and principles shape not just the big transactions, but the everyday interactions and expectations in our communities, from, the ground beneath our feet to the contracts in our hands.
For your own continued exploration, consider this. How might the ongoing evolution of artificial intelligence and blockchain technology, beyond just digital photo editing, continue to reshape the legal, ethical, and practical responsibilities of real estate professionals and property owners in the years to come? AI and blockchain in real estate.
This ever-changing field always offers more to learn, and staying ahead means anticipating the next wave of challenges and opportunities.